That Judge Chutkan has said that she will rule on this, on the scheduling matter, by the end of today, which is another contrast from Judge Cannon down in Florida, who took months at times to rule on these kinds of motions. And what the special counsel wants to do is for both sides to file detailed evidentiary briefs, making their arguments about what should be considered immune and what should be included based on this new superseding indictment. And that could include grand jury testimony and new evidence that the public hasn't seen. And that's pretty significant because that could mean that before voters go to the ballot box in November, they're going to learn new things about this very serious criminal case against Donald Trump, which accuses him of conspiring to defraud the United States of America. Now, Trump's lawyers obviously do not want that to happen, and they are arguing for a lot of different reasons to delay this thing. They want to actually argue about whether the special counsel was appointed inappropriately before they get to this question of immunity. Judge Chutkan does not seem to be heading in that direction, and she's moving things very quickly. And so we're going to know probably by the end of today how this case is going to shape up over the next few months, Jose.
Katie, what do you make of what's happened so far?
I think it's fairly predictable. If you've watched Judge Chutkan, she's efficient and she does not suffer fools. And before this case kind of was, the brakes were hit on this because everything went to the Supreme Court, we saw her moving at a pace of making sure. Remember, this was set for trial in March of this year,
right,
Jose. And so she's basically putting everyone's feet to the fire, in fairness to both sides, to say, hey, what's the delay here? Critically, what we're seeing happening right now is important. One, Trump wants to have an issue dealt with preliminarily before the immunity issue. He wants to deal with the special counsel's appointment, whether it's valid or not. We saw that was the basis for Judge Eileen Cannon to dismiss that indictment wholesale here in Florida. But Judge Chutkan just said right now to John Laura, the lawyer for Trump, she said, there's D.C. Circuit precedents that doesn't say that the special counsel must be appointed in the manner in which you've argued in front of Judge Cannon. She also actually makes a little bit of a dig at Judge Cannon. She says that's another district court, and I do not find that to be binding on me. And so she says, look, I'm going to allow you the following, which is really not a green light. She says to Trump's counsel, I'll allow you to file a motion for leave to file this motion.
Okay, explain that one.
Okay, so normally you can file a motion if you are within the time frame to do so. In this instance, she says, Trump, you had time to do it. You didn't do it before. I'm going to allow you to ask me for permission to even file that. I'm not going to let you just file the motion. You're going to have to ask me for permission, and you're going to have to explain why that D.C. binding precedent that I have that tells me that Jack Smith can be your special counsel, why that doesn't bar the motion that you want to bring. This is important because Trump wanted to delay the immunity considerations till way into December, almost January of 2025. And so if this issue of Jack Smith is dealt with cleanly and quickly, we can get to the immunity issues very quickly.
So the issue of the Jack Smith legality has already been dealt with.
It's already been dealt with in Judge Chutkan's circuit, right? She's already said, you know what? There's another higher court called the appeals court that has told me that special counsel Jack Smith can continue and be the special counsel. It hasn't been dealt with yet in this case. Why? Because Trump was asleep at the wheel and didn't file the motion when he was supposed to before the deadline.
Maya, what are you looking at for today's hearing?
Rationality. I think Katie just laid it out quite well, that Judge Chutkan is being very rational and very clear about managing her courtroom. And I think that the real mic drop, which we just talked about, which Ken named, is the fact that she said, I'm not looking at this as an election. I'm looking at this as a 4-count indictment, meaning she's doing her job. On the special counsel question, this isn't exactly the point of her doing her job. She's saying, yeah, defendants get the right to mount legitimate defenses, but you don't get to do it any old way you want to in order to delay this so that, potentially you can just delay it out of existence. She's saying there is an indictment here. My job is to address it. And by the way, the immunity questions here are history making. I do want to say that, if you really want to get to the meat of the questions here, it is the question of whether Mike Pence, as a candidate talking to his ticket mate, is or is not engaging in official acts in those conversations in terms of what the president is doing. And I think that is both history making. This is going to be the first court in the land that would be looking at and applying this very radical new Supreme Court precedent. And the whole special prosecutor discussion really is a distraction, and it also serves a political end for Donald Trump, the candidate, which is to continue to lay a foundation that says our elections aren't free and fair. This is election interference, and that is not true. And her job is to get to what this case is really about, and I think that's what we're seeing.
Yeah, and Katie, just wondering what both of you have just mentioned about the whole issue of Smith and the legality behind it. There is no, legally speaking, requirement for one courthouse or judge to accept another judge's decision on something like this because of jurisdiction, or is there?
Yeah, that's an important kind of distinction with a difference here. I kind of look at trial courts, appellate courts, and then ultimately the United States Supreme Court is the one that's over every court, right? But when it comes to federal courts, they're different jurisdictions, as you note. And so because a trial court in Florida decided with Eileen Cannon that the classified documents case couldn't move forward on the issue of Jack Smith being special counsel, Chutkan says, listen, I know that exists, but I have an appellate court above me called the D.C. Circuit Court of Appeals, which has already ruled that special counsel like Jack Smith can proceed. And actually, Jack Smith as special counsel, not in this case, but in other cases, has been deemed to be okay to proceed. And so she's like, I appreciate that, but it doesn't move the needle for me. I'm more focused on whether or not the immunity can be dealt with in an expeditious manner. And she's telling the lawyers for Trump, I don't care if there's a presidential election. This case has to move forward. It's been on the back burner for a year and some change, and because of that, we needed to actually have some speed, and you have to appreciate the reality that's going on here. She made it clear at the very beginning of this case with Donald Trump, she was going to treat him like any other criminal defendant. No special dispensation, no special favors, and she's making that clear that because there's a pending election, it doesn't actually require her to be worried about that. She has a mission and a job, and that's what she's going to do.
Maya, if you would describe to us that aren't so steeped in the legal world, the whole issue of, as you were talking about, the historic nature, right, of what this case is looking at. And I'm just wondering, when you talk about immunity and not immunity, and now they're talking about, for example, Fisher, the SCOTUS case that narrowed one of the charges against Trump on issues of immunity, how is this issue of immunity, to use your words, historically different, and what are the implications of that?
Well, just remember, historically speaking, during Watergate, there was no question to the special counsel in the Watergate case that Richard Nixon could be prosecuted. The decision not to prosecute him wasn't that it wasn't constitutional. It was the embedded assumption in our legal system and generally accepted that, of course, a sitting president is not immune from criminal prosecution, particularly after leaving office. And if you notice what Jack Smith did in his superseding indictment and in his revised indictment, he used the language very clearly. This is about citizen Trump. This is about candidate Trump. And if you're having a conversation with your vice president because you are the president, the vice president is the vice president, and you're doing the people's business, that is one thing. But the historic nature of saying you actually have to decide if a conversation between a candidate for office and his running mate about whether or not they're going to use the powers of the office to thwart an election count that is embedded in the Constitution in terms of the power of Congress, and in which there is a federal statute, and in which even Mike Pence, as both a vice president and a candidate, thought, no, I can't do this. This is the question, a question that none of us in the legal I won't say none, but the vast majority of the legal profession would have never understood to even be a question. And that's what we're looking at. That's what Judge Chutkan is looking at. And this is going to be the first federal court in the land to take up the question in this case, for any case, now that this is binding precedent on every single election, every single president, and what every single president does from here on out, as long as this is the Supreme Court case that is not overruled.
Monumental is what this really is all about. And Ken, with all of these issues that have to be decided and handled by the judge, right now they're saying 2 discovery-related motions that you filed. The judge is telling the defense. Those are awaiting reply briefs from the defense. Ken, what's the process going forward today, and how long will this possibly last?
That's the big question, Jose. So the defense is obviously trying to delay. They want Judge Chutkan to rule on these other motions, including separate motions to dismiss the indictment, before she gets to the heart of the matter, which is which conduct can stay in this indictment and which should be excluded based on the Supreme Court decision. The special counsel wants her to take that first because that's the Super Bowl. That's everything. Because once you decide that, you shape how this case goes forward. And just so folks understand, whatever Judge Chutkan decides on that can be appealed all the way to the Supreme Court. It's called an interlocutory appeal before a trial. And that's why there's no way there could be a trial before the election. It's also why there's not going to be a trial anytime soon, even if Donald Trump loses the election. If he wins the election, obviously, when he takes office in January, he's going to order his Justice Department to make this case go away. If he loses, though, eventually it seems likely that he will stand trial in this case, but it won't be for some time, Jose.
Ken Delaney and Katie Fang and Maya Wiley, thank you both. All three. Thank you very much for being with us. We're going to keep monitoring what's happening in court and bring you, of course, updates throughout this hour. Still ahead, we're just 5 days away from the first presidential debate. What we know about the rules Trump and Vice President Harris have just agreed on. Plus another community in mourning after a deadly school shooting. But we're learning about the victims. And text messages shared between a mom and her son during the shooting. We'll speak with her about what she calls her worst nightmare. We're back in 90 seconds. You're watching Jose Díaz-Balart reports on MSNBC.
Gusto is the #1 choice for small business payroll. It's fast. It's trusted. It's a great value. And Gusto does a lot more than payroll to make running your business easier. Like payroll taxes and compliance, time tracking and contractor payments. And when you're ready, benefits, HR, and more. Put your business on the #1 payroll platform. Get started for free at gusto.com.
This is ludicrous.
Ludicrous. All right, who called for ludicrous?
Sorry,
we went, this is ludicrous.
Yeah.
Oh, you don't tell ludicrous what's ludicrous. Ludicrous tells you what's ludicrous.
Okay.
Oh, that is ludicrous. You don't need me for this. Hang on. Like a good neighbor, State Farm is there.
Good thing you have State Farm. Just file a claim on the app or call us.
Guess I can go.
Don't you mean roll out?
No, I don't.
Like a good neighbor, State Farm is there.
Dad, with this Fox tea, I could be class president. And with Target Circle, we save automatically. I'll run on a platform for longer recess and having the cool Fox tea. Vote Claire.
Democracy is egalitarian, which means it's for everyone. But it also, I think, is a divinely inspired gift of our forefathers to show us that we can lead ourselves.
Fifteen past the hour this morning, a Georgia community in mourning and searching for answers after a gunman opened fire at a high school outside Atlanta on Wednesday, killing 2 students and 2 teachers. 9 others were injured, all of them expected to recover. The suspect, a 14-year-old student who officials say was previously investigated